This is Barry Zalma, Zalma on Insurance. Today I'd like to talk about the equitable remedy of rescission and how one court dealt with a series of facts to conclude that rescission was appropriate. I am an attorney, presently retired from the practice of law, and now spend my time as an insurance claims consultant, an insurance claims expert witness, an author, and producer of these videos. In a California case called Mitchell versus United National Insurance Company, which was decided by the California Court of Appeal in 2005, the court affirmed and enforced California's marine rule with regard to rescission of insurance policies. By affirming the rescission of an insurance policy because of the misrepresentation or concealment of material fact by Mr. Mitchell, the court defeated an argument that statutory language in a policy of insurance changed the law of rescission. The Court of Appeals summarized its holding as follows, quote, "An insurer may, under California Insurance Code sections 331 and 359, rescind a fire insurance policy based on an insured's negligent or unintentional misrepresentation of a material fact in an insurance application, notwithstanding the willful misrepresentation clause included in the required standard form fire insurance policy, which is California Insurance Code sections 2070 and 2071. Mitchell, individually, was the named insured under an insurance policy issued by United National that provided coverage for a commercial building owned by the Mitchell Family Trust in Los Angeles. During the policy period, the building was destroyed by an arson fire. The arsonist, an acquaintance of Mitchell's, perished in the fire. In the ensuing investigation, United National discovered several misrepresentations in Mitchell's application for insurance, rescinded the policy, and offered to return Mitchell's premium. Mitchell sued, and United National moved for summary judgment on two alternate grounds: material misrepresentation in the application for insurance gave United National the right under Insurance Code sections 331 and 359 to rescind the policy, and the policy's dishonest act exclusion barred coverage because Mitchell's representative, to whom Mitchell had entrusted the property, intentionally set fire to the property. The trial court granted summary judgment on both grounds. Mitchell purchased the building in February of 2000 in the name of his trust. On April 11, 2000, Mitchell's brokers submitted an application for insurance to Deborah Messina of Excess and Surplus Lines Insurance Brokers, Inc., an authorized underwriter for United National. The application made certain material representations upon which the underwriter relied in deciding to insure Mitchell. 1. The property to be insured consisted of a 3,420 square foot commercial building. 2. The building was to be used by Mitchell as a video production studio and offices. 3. The business to be conducted in the building had $20,000 in payroll and generated $300,000 in receipts. 4. There was no existing insurance on the building. 5. The building had no uncorrected fire code violations. 6. the building had a burglar alarm, and 7, Records and Film Works, Inc., later changed to James E. Mitchell, was the purchaser of the building. In fact, the evidence collected by the insurer established that 1, the building was less than 2,000 square feet. 2, the business conducted in the building had no officers or employees, was used only to film a music video for 2 days in May or June of 2000, and was leased to a tenant who operated a garment business. 3, the business in the building generated approximately $6,500 in receipts from February 2000 to the time of the fire. 4, the building was insured by the California Fair Plan, an insurer of last resort. 5, the building was subject to a City of Los Angeles abatement order stating the business could not be occupied without a clearance or repaired without a permit, and contained such deficiencies as being open to unauthorized entry, littered with combustible debris, excessive dry weeds or vegetation, broken windows, damaged or missing doors, damaged exterior wall covering, and deteriorated flooring, and no permit had been obtained for corrective work on these deficiencies. 6, the building had no burglar alarm. And 7, the building was owned by the Mitchell Family Trust. In addition, it was established by United Nationals' thorough investigation, including the examination under oath of Mitchell, taken by me, that in July of 2000 he rented the property to a tenant who operated a garment manufacturing business. In August of 2000, a city inspector cited the tenant for failure to obtain a certificate of occupancy, and Mitchell was forced to release the tenant from the lease and return most of the rent payments. The property was vacant on November 22, 2000, the date of the fire. According to Mitchell, before the property was damaged by the fire, he met Carl Robinson, who represented himself as a business consultant with a prospective buyer for the property, and gave Robinson the keys to the property for the purpose of showing it to the prospective buyer. On November 22, 2000, while Mitchell was in Chicago, Robinson set fire to the building and was himself killed because he couldn't find a way out of the building after he ignited the fire. In his first amended complaint, Mitchell admitted that the application for insurance submitted to United National contained inaccuracies that caused United National to rescind the policy, but claimed that those inaccuracies were not material and were solely the fault of his brokers. Ms. Messina, the underwriter, stated in an undisputed declaration that the size and condition of the building, as well as its proposed use as an owner-occupied business, were important factors in rating the risk to be insured against and deciding whether or not to issue an insurance policy. She further declared that had she known, 1, that there were uncorrected fire code violations, 2, that the building was substantially smaller than had been represented in the insurance application, 3, that the property was not to be used as studios and offices for Mitchell's own music video company, she either would have underwritten the policy differently or declined to underwrite it altogether. That the existence of prior insurance coverage under the California Fair Plan was also an important underwriting consideration, because such coverage indicated past problems in acquiring insurance. Messina said she would not have issued the policy had she known all those facts. The trial court granted summary judgment in United National's favor, finding that as a matter of law on the undisputed facts, that the information sought by United's underwriter and denied to it by plaintiff's false answers and omissions was material to United's decision to provide insurance coverage. The uncontradicted evidence of United's underwriter confirms the importance that United attached to the information. Under these circumstances, the materiality of plaintiff's concealment was established as a matter of law. The trial court further concluded, in addition, coverage is excluded because the loss was the consequence of the dishonest act, arson, of plaintiff's authorized representative, to whom he entrusted the property for the purpose of showing it to a potential buyer. The Mitchell Court, in conclusion, stated that, quote, Insurance Code Section 332, for example, requires each party to an insurance contract to disclose in good faith all facts within his knowledge which are or which he believes to be material to the contract. The disclosure obligations imposed by these statutes are directed specifically at the formation of the insurance contract. Insurance Code Section 334 states, quote, subquote, materiality is to be determined not by the event, but solely by the probable and reasonable influence of the facts upon the party to whom the communication is due in forming his estimate of the disadvantages of the proposed contract or in making his inquiries. Insurance Code Section 356 provides, quote, the completion of the contract of his insurance is the time to which a representation must be presumed to refer. The Court of Appeal recognized that the reason for the right to rescind is in support of the party's freedom to contract. The Court of Appeal felt that an insurance company has the unquestioned right to select those whom it will insure and to rely upon him who would be insured for such information to the end that a wise discrimination may be exercised in selecting risks. Citing the history of rescission in California, the Court of Appeal recognized that it was applying a long line of California decisions. Mitchell's application for insurance contained misstatements of fact concerning the size and use of the building, the existence of building code violations, and the existence of insurance coverage for the property. The materiality of a misrepresentation is determined by the probable and reasonable effect upon the insurer. When deciding to rescind or not rescind, an insurer should consider, according to the Court of Appeal, whether the information would have caused the underwriter to reject the application, charge a higher premium, or amend the policy terms had the underwriter known the true facts. The misrepresentation need not relate to the loss ultimately claimed by the insured. Whether the decision to enter into the contract in estimating the degree or character of the risk or in fixing the premium rate thereon. Therefore, materiality is determined by the probable and reasonable effect the truthful disclosure would have had upon the insurer in determining the advantages of the proposed contract. Ms. Messina's sworn declaration as to the materiality was sufficient to establish materiality and provide grounds for the rescission. The Court of Appeal concluded that the evidence of materiality of the misrepresentations was uncontradicted. The application was for significant insurance covering the peril of fire. The information sought went directly to connections and questions of insurability, risk, and premium. The insured admitted that there were misrepresentations on the application, and the insurer considered the information important to its underwriting decisions. With such overwhelming facts, the Court of Appeal concluded, using a double negative, that a reasonable trier of fact could not find that the representations in the case were not material. Since the court's conclusion on rescission resolved the entire case, it declined to discuss the intentional act portion of the policy. Every California insured and every broker representing insureds must treat applications for insurance seriously. Answers must be accurate at the time the application is submitted to the insurer for a decision to insure or not insure. Misrepresentations or concealment of material facts, whether intentional or innocent, can leave an insured with a legitimate claim without coverage. Although Mitchell was apparently not innocent in his misrepresentations, his representative burned the building intentionally and so incompletely that he died in the fire. Admission that facts established as material were misrepresented on the application was sufficient to allow United National to rescind, and it avoided the need to prove its insured hired a person to burn down the building. This case also is useful to every insurance claims person who finds material misrepresentations and requires, before making a decision to rescind, to not only obtain the advice of an independent, knowledgeable insurance coverage counsel, but also to, before deciding to rescind, interview the underwriter and obtain a sworn statement from the underwriter about the materiality of the facts. With the sworn declaration of Ms. Messina, which was obtained before the insurer even advised the insured of the rescission, the court had no choice but to determine that the policy was acquired by a false application and that the policy never existed, and that it was rescinded ab initio, or from its inception. This video was adapted from my book, Zalma on Insurance Claims, Part 104, 2nd edition, and is available as both a Kindle book and as a paperback from Amazon.com, and can also be found with details at my website, Zalma.com, by clicking on the link to the Insurance Claims Library. If you found this video to be useful to you, please refer it to your colleagues. Subscribe to my YouTube channel and to my blog so that you can learn about future blog postings and future videos. Thank you for your attention.